Hello everyone, we will now proceed to our discussion on Article 282 or grave threats. It defines as any person who shall threaten another with the infliction upon the person, honor, property, or of the latter or his family of any wrong amounting to a crime, shall suffer the penalty of arresto mayor and a fine not exceeding 500 pesos. This one is already amended by Republic Act 10951 entitled an act adjusting the amount or the value of property and damage on which a penalty is based. So now the fine is defined as any person who commits grave threats will also face a fine of 100,000 pesos. So ito yung mga salitang may kasamang pananakot at pag nabitawan mo ito, maghanda ka ng 100,000 pesos. Actually, there are three kinds of grave threats. The first one is a threat without any condition. Sabihin mo lang, sige, papatayin kita. That is a threat without a condition. A threat subject to a condition is, sige, papatayin kita kapag hindi mo ako binigyan ng pera. Asking money is extortion. There's also grave threat subject to a condition not amounting to a crime. You will say, sige, papatayin kita kapag hindi mo ako pakasalan. The condition there, hindi mo ako pakasalan, does not amount to a crime, but your threat comes with a condition. With that, we will now discuss the elements of grave threats. First, that the offender threatens another with the infliction upon the latter's person, honor, or property, or upon the latter's family of any wrong. That such wrong amounts to a crime. So the threat here, the infliction of a threat, will fall under crimes against person, crimes against honor, or crimes against property. We will later give examples of this kind of threat. And that the threat is not subject to a condition. This felony is consummated as soon as threat come to the knowledge of the person threatened. So if your threat does not come with a condition, yung sasabihin mo lang, papatayin kita, automatically, this is already a consummated stage because the term papatayin kita is one word. Pag sabi mong pa, you cannot say that is attempted pa or frustrated papa and consummated tayin. So, it has only one bigay ng salita, papatayin kita. The moment you mention the entire word, that is already consummated stage. It does not have any attempted and frustrated. So an example of this was the case of People versus Sabinala Ruzin and a Sandigan Bayan case where the agent there said, putangin na mo klabe, putangin na mo bobot, papatayin kita. So that one is an example of a consummated stage. Before we proceed with other discussion, let us here give focus to the difference between grave threats and light threats. Previously, the Calawag versus People case decided last March 4, 2009, the Supreme Court here said that the light threat and other light threats under Article 283 and 284, the wrong threatened does not amount to a crime, while grave threat under Article 282, the wrong threatened constitute a crime. However, Justice Luis Reyes said that the Calawag case is not controlling because the definition of other life threat under Article 285 paragraph 2 is a mistake, since the Spanish text thereof used the word constituya delito, which words when translated into English means constituting a crime. Therefore, in People versus Medrano, dated February 22, 1968, the Supreme Court held that it was an en banc decision that orally threatening another in the heat of anger with some harm constituting a crime is other life threat under Article 285. So if you threaten another in the heat of your anger, if you will recall our revised penal code book 1, here if the mind is obfuscated, meaning You will say things that you have not thought of. Usually, the penalty is lower. The same here in grave threats. So, if you had said something out of anger, hindi mo na pag-isipan na husto, the Supreme Court in its wise said that it is only under Article 285 or other life threats. So, the People versus Medrano controls the case when it comes to life threats. In addition, the Supreme Court cited U.S. versus Pagueran, a 1909 case, and U.S. versus Estrada, wherein the threat to kill made in the heat of anger is considered as other life threat, although killing threatened to be committed is a wrong constituting a crime. So, this is again the same as the Medrano case. Moreover, other life threats under paragraph 1 of Article 285 involving threat with a weapon. So, such threat with a weapon amounts to a threat to inflict harm constituting a crime such as physical injuries or homicide. In some, even though the offender in this crime is not uttering threatening remarks, wala siyang sinabi, such as papatayin kita, he is impliedly threatening the victim with the infliction of injury by drawing, holding, or brandishing the weapon in a threatening manner. Infliction of injury threatened to be committed is a wrong constituting a crime. So, despite of the Calawag case, grave threat, life threat, and other life threat should be distinguished as follows. Grave threat and life threat can be committed orally or in writing. Meaning, you can write your threats. This is common in the Facebook. There, some people there will threaten another by posting something in Facebook. That is an example of threat in writing. Other life threat of the first form is considered with the use of weapon. Ito yung mag-brandish ka ng mga kutsilyo. Other life threat of the second form and third form must be made orally. So meaning face-to-face. Grave threat can be committed with or without demand for money or imposition of condition. This is my example before. Yung sabi lang papatayin kita, that is threat without condition. Or if you demand money, that is threat with a condition. Life threat must be committed with demand for money or imposition of conditions. So meaning in life threats, there must be demand. Bigyan mo ng pera or other condition. Other life threat must be committed without demanding money or imposing conditions. So this is the difference between life threat and other life threats. The first one is it has demand for money. The other one does not have any demand for money. In grave threat and other life threats of the first or second form, offender threatens to inflict a wrong constituting a crime. So meaning, in grave threat and other life threats of second form, there, the condition must constitute a crime. In life threat and other life threats of the third form, offenders threaten to inflict a wrong not constituting a crime. So, the offender threatens another person with the infliction upon the latter's personal honor or property, upon the latter's family of any wrong. An example of these crimes against person, crimes against honor, or crimes against property are follows. So when you threat a person to commit, when you threat him, like for example, if you will not give me money, I will kill you. So that threat is crimes against person because killing a person might constitute homicide or murder. So that is crimes against person. And the second one is crime against property. So if I will say, if you will not give me money, I will burn your house. Burning the house constitutes arson. That is crime against property. The third threat can be crimes against honor. So for example, what are crimes against honor? These are, example of this is libel. Sige, if you will not give me money, I will publish something against you like drug addict ka, nabibilot na ka ng shabu, or kurakot ka. So that is a libelous statement. So that is crime against honor. Let us now hear the case report of Silvano Camilo on grave threats.
United States versus Sofronio de la Cruz. This case is under Article 282, grave threats. There are three elements of grave threats. Number one, that the offender threatens another person with the infliction upon the latter's person, honor, or property, or upon that of the latter's family of any wrong. Number two, that such wrong amounts to a crime. Number three, that there is a demand for money or that any other condition is imposed, even though not unlawful. Number four, that the offender attains his purpose. The facts of the case are as follows. Sofronio de la Cruz was charged with having threatened Dolores Coronel in a letter with death or the burning of her house unless she gave him 500 pesos, which she must deposit in the place indicated to her in the letter. This letter was found by Rafaela Coronel, who was living with Dolores, in the fence around her house, and as she was then on her way to church, she turned it over to her neighbor Agustin Coronel. The contents was read to Dolores Coronel, a 70-year-old woman who became nervous and uneasy upon seeing herself thus threatened. Tito Coronel reported the matter to the municipal president of Guanga, Pampanga, who went to Dolores' house and adopted some precautionary measures. Upon returning to the town hall, he found a man held under arrest by the constabulary. He had him searched to see whether he was carrying any prohibited thing. There was found upon him an envelope inside a pocketbook, and upon the envelope was written the name of Dolores Coronel. The man under arrest was Sofronio de la Cruz. The issue of the case is whether or not the accused be penalized for the crime he threatened to commit. The court ruled yes. The conclusion in law therefore is for the guilt of the defendant, who is guilty of the crime penalized in the Article 494 of the Penal Code, and there must be imposed upon him the penalty lower by 2 degrees than the fixed by the law for the crime he threatened to commit. For having made threat and demanding a sum of money, even though he did not obtain it, the penalty should be in the maximum degree, however, as he made threat in writing.